the trustee has to be another parent, the other biological parent whom you may hate. Hi, Jeff Masachi, the Plain English Attorney, and welcome to the video. And we've got a good one today. This is a big amount of confusion over what's terminology and a huge kind of disjoint and disconnect among the attorneys trying to give advice in what really seems to be that the person posting the question isn't really sure what they're asking, or they've misheard things. So, jumping right in, question on inheritance for grandkids. Hi everyone, not sure if this is the right forum for this, but I couldn't find an answer on Google. Here's my question. My mom is writing up her will. I have 2 kids, her grandkids, with 2 different dads. I am married to my current husband who I share my youngest daughter with. My son's father is not involved. My current husband raises my son and has been in his life since he was 18 months old. He is now 4 years old. My mom is setting up who will be the beneficiary for the grandkids' inheritance. If one of her parents dies, when she asked what I should do for my son, I suggested she list my current husband, his stepdad. She said that was good. And then later said by law she has to list the parent, as in next biological parent. Is this the case? And apologies if this question and case is confusing. Also, this is Illinois. Yes, it actually is a little confusing. But here's where I'm seeing, you'll see right now coming up, the attorney just kind of jump to the terminology they're using, and they are not looking, and they're assuming the worst of the attorney. Is she not setting up trust for the grandkids? She can name any trustee she wants in that case. That's true. She can name whoever she wants as trustee. Your mom and you should stop listening to anyone who is not a licensed attorney in Illinois. Go schedule a consultation. Trust me, it's worth the price. I'm constantly fixing self-drafted or computer-drafted wills. She didn't seem to say that her mom was going anywhere other than an attorney, but they assumed the worst.
If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel.
Yup, she's working with an attorney who said by law the child's other biological parent has to be listed as the trustee. Like if I died prior to my mother, then my ex-husband by law has to be my son's trustee of any money my mom has for my son. I just wasn't sure if my mom misunderstood or if she's just saying it has to be biological parent by law. My ex-husband is estranged from my mother, so it just seemed a little weird to me that by law he would need to be listed as opposed to anyone else as an option. All right, yeah, that actually is crazy, but really, mom's working with an attorney. Are we going to assume that the attorney is this incompetent that they would automatically say no, the trustee has to be another parent, the other biological parent whom you may hate? No, God no, that's not the case. Okay, quoting attorney who said by law the child's other biological parent has to be listed as the trustee. She needs a better attorney because that's bullshit. Sounds to me like the attorney is not a trust estate specialist, which is what she needs. In my experience, attorneys who only dabble in my field have a tendency to be wrong. Okay, going full on against this attorney. They absolutely don't know what they're doing. All right, as we move a little bit further, I think we're going to see what's really going on here. But the commenting attorneys they're just viciously going after assuming incompetence. No, she doesn't have to list the parent. She can list anybody she wants. If she can give away her stuff in life, she can give it away in her will. Note, however, that minors cannot directly inherit except small amounts. If she wishes a grandchild to benefit, then some sort of trust is needed. A trust must have a trustee who can be any competent person. If a large amount of money is involved, there are banks and other institutions that can take the job. Individual or bank, a trustee is entitled to a fee. Close relatives often waive their fee, but there will be other expenses, accountant, lawyer, investment advisor. And following up, I said any competent person can be the trustee, but an out-of-state trustee has its special problems. Okay, all of that's true, but again, we're assuming that the information went from attorney to mom, to really grandma of the beneficiary. From attorney to grandma, grandma to mom, and now mom's posting accurately what the attorney actually said. I think that's a huge assumption, and I believe it's wrong. And here's where my response comes in. I think there is some confusion on terms here. Most people in this situation want the grandchildren to inherit the money, and they are the beneficiary or beneficiaries, and not the parent or step-parent. In many cases, there is also an age of inheritance listed in the will or trust to prevent a young but still legal adult beneficiary from getting the money too early. In these cases, a trustee is needed to oversee the inheritance, manage investments, and pay for expenses, etc., until the beneficiary reaches the age of inheritance. Something completely outside the control of your mother is who will be your child's parent or, quote, guardian until they reach legal adulthood should you pass on, which, I believe, is universally the age of 18. Until your child turns 18, money your mother may leave behind for your child being used for the usual support items can't legally be handed to the child, and if not being used to pay directly for services, would go to your child's guardian to be used for them. That's probably what the attorney was saying. It's, well, who receives the money for that grandchild? Well, it's got to be the parent of the child or the legal guardian of the child. They receive that money until they turn 18. So let's finish this out. The attorneys commenting here rightly point out that your mother can choose anyone she wants to be trustee, and I think your mother may be miscommunicating what the attorney said in that it sounds like payments may have to go to your child's legal guardian up until age 18. You posted that your son's biological father is not involved, but you didn't mention whether or not his parental rights have been terminated and or whether or not your husband has adopted your son. I think this may be just a combination of confusion over terminology and the old game of telephone, where a message from the attorney got distorted when passing through your mother to get to you, and how you interpreted the message. That's really it. We've got these three roles. There's who is the trustee who's managing everything. Who is the beneficiary? If you pass on, it's going to your son. Your son is this beneficiary we're talking about. And then who would be the guardian to actually get some payments up until they turned 18? That's the guardian. I think the attorney's point to your mother was, look, we can't direct that it has to go to the stepdad because it's not the stepdad's child. They're not the guardian. If it's for the benefit of the grandchild and the money needs to go to a person other than the grandchild, which you can't, it's got to be that biological parent who is going to end up being the guardian. That's the point I think the attorney was making. And of course, the terminology just got confused. All right, so I hope I didn't confuse you. I hope you found that information useful. If you want to learn more about estate planning, we've got at my book, Estate Planning Basics, available at Estate Planning Basics Book. And we also have the audiobook, which is actually cheaper, Estate Planning Basics Audiobook, and we'll put the links in the description below. So please, as I always tell my clients, stay safe, plan ahead, and enjoy life, and whatever you do, make it a great day.